Yeah. Very good afternoon, everyone. I am CSR Venkatramana, Council Member of ICSI. I extend warm welcome to all and especially eminent dignitaries from Ministry of Corporate Affairs and CRC Mane sir and all the participants for this Master Knowledge Series program called Triple E 6.0 version. It is Enable, Enrich and Excel on the topic of companies incorporation and name reservations. As with the company secretary started our journey as a name incorporation and name availability, we are when putting a lot of efforts and still struggling with some of the issues. So MCA officials have come up here to help us on this occasion of the new beginning of the financial year, 1st April. It is a privilege to inaugurate the first webinar of a Master Knowledge Series Triple E 6.0 as we step into a fresh life cycle of opportunities and responsibilities. This series aims to empower the professionals with enhanced expertise, evolving insights, and excellence in practice. So, this initiative set the tone for continuous learning, knowledge sharing, and professional growth throughout the year ahead. Friends, this Triple E series, National Knowledge series, is taken up most valuable topic, vital topic of professional interest, companies incorporation and name reservation. The Central Registration Center is an initiative of Ministry of Corporate Affairs in government process re-engineering with specific objective of providing speedy incorporation and related services for companies and LLPs, keeping in view of the ease of doing business. Friends, the Central Registration Center plays an important role in modernizing India's governance framework by streamlining and simplifying the processes of company registration and compliance. It establishes the government commitment to improve the ease of doing business, encouraging entrepreneurship, and fostering the economic growth. Friends, on this occasion, I would like to also mention that and some updates from the ICSI in alignment with the MCA for the benefit of the members. The ICSI has launched a dedicated email ID Companies Act 2013 at icsi.edu and dedicated 3 Zoom helplines we have been provided. 4 consultants of ICSI at MCA office for resolution of V3 issues. And we have conducted several webinars on IEPF, MCA 21V3 and MCA 21V3 on login and registration and issues relating to e-forms. And thanks to the Ministry of Corporate Affairs for through their regional director and other offices conducting the meeting of stakeholders for grievances and redressal mechanism, query resolution through query resolution mechanism and grievance resolution mechanism. Friends, we have been continuously giving the representations to the ministry, and the ministry was so kind to understand our problems and giving, and we have now got the scheme also. We have a scheme which will be very much useful for all of us. And on our request, it is a important thing to note that a mechanism of filing a resignation of KMPs, especially company secretaries, where companies are not filing the DR12s in relation to resignations. Now, in the new amendment bill, the proposal is there that DR11 mechanism may be introduced even for the KMPs. This is a very good initiative, and today, friends, we have great personalities from the Ministry of Corporate Affairs. Shashira Dara sir, he's the Director, Central Facilities Director and Public Grievances MCA. And Varun sir, Joint Director, DGCOA. And Anil Yadav sir, ROC CRC Manager. And Sanjeev Jain sir, Deputy ROC CRC Manager. They are available for us. Shashira Dara sir was heading e-governance cell earlier. He knows in and out of the MCA issues, e-governance issues. So his presence will make a lot of difference for us in this session. And we have special remarks from the regulator itself. We are honored to have Sir Varun sir. We welcome you. Shishra sir, we welcome you for this session. Sir, we also welcome Anil sir, ROC, CRC, and Sanjeev Kumar Jain sir for coming over here, spending their valuable time for giving their technical insights on functioning of CRC and name approval mechanism, incorporation mechanism. So friends, now I welcome everyone to this vital webinar and encourage all the participants to raise their queries, which will be taken up either during the webinar or at the end. So I welcome once again. Now I request a special address from the Shashiraz Dara sir for all our members. Shashiraz sir, you
Thank,
can take up,
yeah.
sir.
Thank you, Venkat. Thank you, Venkat Ramna. Uh, Thank you. We have to thank ICSI for giving us this opportunity to present our views on CRC. As Venkat has introduced, that CRC was started in 2016. Then we started making improvements every year. And today's state, we have reached a place where we are able to confidently say that we are able to give a name in 2 hours and incorporate a company within a day. All credit goes to the people working hard behind CRC, the unseen heroes behind CRC, the DH, dealing hands. Of course, regarding dealing hand, we have to make it that ICSI has been supportive in our journey from 2016 till date. We have replaced, we could achieve these things because of a lot of support from ICSI members. We have started taking professionals into CRC. Then the initiatives told by Venkat Ramna, we are coming out with different other initiatives also. Like we are going for a change in name rules. We are finding based on the queries raised, based on the complaints requests from members, requests from promoters, shareholders, and other bodies. We are started a concept called GRM and QRM at all regional level offices. GRM and QRM is already there for CRC, which we are, which is a robust mechanism, which maybe many people are not aware. Anyway, we'll bring it to their knowledge through one or more webinars like this. We are coming up with rule changes, incorporation rule changes, so that we'll make incorporation faster. We are also planning to come up with something called a green channel, which has been going through for many years, so that we can give incorporation, name availability in faster manner. The faster manner is less than 2 hours and less than 6 hours for incorporation. This is the mechanism which we are trying to go ahead. Other initiatives relating to Companies Act changes. We can at this forum come up and tell that we are also trying to bring a 360-degree change in e-forms. Every e-form we are trying to re-engineer it, reduce the number of e-forms, reduce the number of information required in the e-forms. These are the initiatives which are going on, for which we will again be conducting different sessions throughout this with the help of ICSI and ICAI. So without wasting much time, I want all the members to interact with my team, Varun, Joint Director, Anali Yadav, ROC CRC, and Sanjeev. You have got good resources. Please use these resources. Get as much as information you want and doubts cleared from this one. Thank you, Venkat.
Thank you so much, sir. Now I request Varun sir, Joint Director, to address our members.
Thank you, sir. It was a wonderful opportunity from ISC side that this clarification can happen through this webinar on various issues plaguing the stakeholders. In fact, this advisory that we have issued recently, I think that is required to be clarified more. I think the prime objective of this particular webinar is the clarifications on the advisory. So I'll try to structure my views on around the advisory mostly, and any further clarifications, Anil sir will also chip in. So this advisory is basically a product of going through the resubmission remarks, rejection remarks of Central Registration Center. Now CRC is supposed to be key for ease of doing business. Yes, definitely they are working very hard, but even then there is some information asymmetry that does happen between what is there in the rules act and what does come across in the remarks. So basically we try to go through the remarks and see where we can actually plug the information asymmetry. So that's why we brought the advisory, so that these resubmissions, rejections can come down significantly, and further contribute to ease of doing business at the time of incorporation and name reservation. So when we see the advisory, there are some things which are coming out very clearly the first time. Like you can see that certain remarks that were very common, but those were known to people who were filing for incorporation or name reservation or already filed. They would be knowing that these kind of remarks would be coming. But by putting this advisory, this is going to be in public domain now, and therefore those who are going to file for incorporation, name reservation, they'll be knowing in advance that these kind of queries are expected, and therefore they can take caution to ensure that this is already clarified at the time of submission of the form in the first submission itself, so that it does not require a secondary submission or a first resubmission, as the case may be. Now, if we go through the advisory, we have given recent instances where existing names are there and what the proposed names came through from the name reservation applications, and why they were rejected. We have given examples. Like for example, you see the advisory. If there was an existing name by the Avon Engineering Private Limited, so somebody goes with a proposed name of Avon Engineers Private Limited. So this was just a plural or a verbal differentiation of variation of the name. So as per the existing incorporation rules, that name could not be given. So essentially, the advisory is nothing but amplifying what is already there in the incorporation rules that is known to the stakeholders. But we are trying to give out more examples so that the communication is more effective that way. So similarly, we have given a host of examples there where slight variations, verbal variations, or plural or past tense variations. These things will not be allowed basically from CRC. That though they may appear to be a different name, these will not be allowed if it is coming in this particular format. Then even when NOC is issued, okay, so there are certain instances where CRC will disregard it. When it is the same name, then there is no point of having the NOC. So if it is the same name, then the NOC will not work. And in going further, you can see that in serial number 3 of the advisory, I hope that everyone has the advisory handy with them so that it is easier. In fact, we can even screen share as we speak. That would be better.
खुशबू जी स्क्रीन शेयर कर सकते हैं एडवाइजरी सर दिस
I'll share it.
Yeah, sir, this advisory has come up very well, sir. 17 pages. Every part of the incorporation and name availability is covered almost.
Yeah, we have got a lot of information and inputs from CRC as well. On this, we have to thank them that they have gone into each and every aspect, and they've given valuable inputs. And let's try to cover it as effectively as possible. So I think we should have the advisory on screen as we speak. That would be better.
Yes, sir. Just give me a minute. Sir, is my screen visible?
Yeah, your screen is visible. Yes.
Yes.
Can we have the latest advisory
Sir,
of?
this is the latest one. This is which we have received on 25th.
Okay.
Yes.
All right. Just give me a moment.
I have the other one also. If you'll say, I'll share that also.
No, the latest one is what would be relevant. I'll just confirm. Can you just scroll through it quickly up to the end?
Yes, just a second.
Can you show me the 57th point in the advisory?
Just a second. This is the last point, sir. 55th is the last.
I think this is the older one, so probably we'll
Okay,
get
just
the
give me 2
new
minutes.
version. Yeah.
Okay, give me 2 minutes. Yes, sir.
Yeah, I think this is the latest one. Yes, fine. We can go to the beginning. Yeah. We can in fact go to third page. Yeah. Yeah, right. Okay. So here, we have tried to tabulate what cases, that should be taken into consideration at the time of giving the proposed name. So many times that name would have been there for another company which is already dissolved, and in another case it can be even struck off. So the timelines are different for a company which is dissolved and liquidation, and timelines are different for a company which is which has been struck off. So that is clear and as per the rule. Then going further, we can see that ROC CRC does insist for NOCs in certain cases where the name contains the word bank, insurance. Okay, so these are the cases where in principle NOC is required from the respective regulator. If it is a bank or insurance is specifically added in the proposed name, this must be enclosed along with the reservation application, which will ensure that it is not further sent for a resubmission, specifically asking for this particular NOC. So then you have architect. If there is a word architect in the name itself, the proposed name itself, then also this NOC is required. However, if the objects alone have architect in its mentioned, then there is no separate NOC required. That is as per the Delhi High Court ruling, that just by having objects architect, there is no need to get NOC from the regulator, architect's regulator. Then we have built-in declaration in the spice party. This is very important. So if wherever this mutual fund or venture capital or asset management, these are forming part of the objects, then in spice part B, a declaration is enabled that the regulators approval, the sectoral regulators approval will be taken and be complied with. So that will take care of the declaration that is required. And one more thing is about, we have seen instances where they will have some kind of a foreign name or foreign word mentioned, foreign country's name or a foreign place name in the proposed name. So these kind of names should not be casually, put in the proposed name. What it causes is basically it will go for a resubmission if there is no adequate justification given for having those words in the proposed name. There should be some kind of documentation that between this particular person who is applying for the name and that particular country or place, some kind of agreement has to be there that justifies the proposed name. So that kind of documentation should be made ready before applying, or if casual applications will otherwise tend to be rejected. And then one more thing is very common that we come across is the application of section 4.3a, where any proposed name, if it constitutes or if it conveys a sense of patronage indicative of from a state government or a central government, then that name can be rejected as per the section. So now this is one of the sections where stakeholders have to be very careful while putting the proposed name. We see that mentioning the state's name, mentioning India in the proposed name. So these kind of proposed names will invite some kind of subjective scrutiny from the ROC. So it is better that stakeholders, as much as possible, steer clear of mentioning any kind of proposed name which is indicative of patronage, unless such a patronage exists explicitly. Now, for example,
Varun,
yes, sir.
Varun, here I would like to
Yes,
interrupt
sir.
you for just a minute.
Yes, sir. Yes, sir.
And I would like to request Venkatramana that after this session is over, kindly share the list, take a feedback from our members,
Yes,
pure
sir.
practicing professionals, and
Sure.
share a list which you feel is should be included or excluded from the list of so that we can make a proper list. We want to
Correct.
update that list
Sure,
because
sir.
every time when we are speaking, you feel that we are speaking from our end, means from the government, and we are trying to tell. It's better to take a feedback and take the additional names which you want to include or any names you want to delete from the list. Kindly share it with us by email to Varun, myself, and Anil, so that
Sure.
we'll be updating the list.
Yes, sir.
Sure.
That's a very
Varun,
good suggestion, sir. Yes, yes, absolutely.
yeah, same as for patronage, heroes, words, what undesirable words. What happens most of the time we say it is an undesirable word, but for professionals or promoters, they may be having a different view. So better is when we have started this exercise, we'll collect a list and we'll update our list. Okay.
Sure, sir.
Thank
Sure.
you.
Yes, sir. Yes, sir. Thank you, sir. That was a very timely, sense of thing that was required. We will require definitely input from ICSI and other stakeholders to update the list. And please, that list may be shared, sir. Yes, as Dara sir is saying. And yeah, I was trying to tell about the patronage issue, and I came across one particular instance where their particular name, though it was indicative of patronage, was allowed because that particular company which was proposed to be incorporated had an MOU with the state government. So in that case, it was okay with the CRC to give the name because there was an explicit agreement with the state government. So there is no problem in giving such a name. So that kind of care has to be taken when you are going for any kind of proposed name which is indicative of patronage. So these stakeholders may please note down very carefully. Because it will require then resubmissions or change of name and things like that. So this is one thing that I would like to highlight. And then one more thing is about a Section 8 company. What should be there in the proposed name? So already the rule clearly mentions foundation, forum, all this. Now, what we have tried to sensitize further is even vernacular versions of this translation of forum or federation. Even these can be allowed. So because the rule says and the like, it does not restrict it to just those words. So CRC accordingly will be looking at this in that sense only, that the rule is being interpreted to include whatever is like foundation, federation, forum, and not restricting only to that particular those particular 8 words. So this is something which people who are proposing a Section 8 company will be wary of. They cannot simply mention company, or they cannot mention society or NGO, indicative of NGO, or something which is not indicative of private company. So they have to make sure that it is proposed name clearly indicates a Section 8 company's formation. And when you come to Section 8 company, it is clear that it is not to be. It is the formation of this company is not for profit, but it does not, however, say that it should not generate revenue. So it can generate revenue, it can indulge in commercial activities. However, they should not be putting their profits for dividends or distribution. So this is one very clear thing that had to be conveyed. So there is no such thing that a company should not be engaging in commercial activities for formation of Section 8 company. They can very much engage in commercial activities, but it's just that the profit should not be distributed in the form of dividend. It has to be put back to the activities indicated in the main objects of the company. Then the CRC would allow such a name. And then for LLPs, specifically ROCs may have made many times the remark that finance activities are not clearly allowed. Now that remark is clearly in line with the Chapter 3B of provisions relating to NBFC, Reserve Bank Act, India Act 1934. So explicitly, the finance activities are not allowed, and similarly, microfinance activities are therefore also not allowed for LLP. So it just needs to be ensured that while selecting the objects, care has to be taken not to include it anywhere in the objects. So that will ensure that the application will not be returned for resubmission or not be rejected. So this is an important point for LLPs that stakeholders should take note of. So, and by way of some SOPs, ministry has tried to streamline name similarity treatment, name similarity conflict treatment. So we have given one example also in serial number 18. So a suitable suffix is added, so it becomes a different name. So then it will result in approval from CRC. So that stakeholder has to be mindful of including a proper suffix. If there is an existing name, and if they want to ensure that their name is different from what is existing, they can actually take this example, and then that is how a proposed name then can be approved, even though at first instance it may seem that the names are similar, but they are distinct enough that it can be approved. That is the approach of CRC, and that's why this example was particularly given. Then going further, we have seen that some cases they first apply for name reservation in LLP, and after CRC approves it, then they say that there was a business change, and then they want to reserve for company and vice versa. So that does not work. So there is no withdrawal provision in the name incorporation rules. That's very clear. Name once given reserved for company, it will be there for 20 days, and for LLP it will be there for a longer time, 90 days almost. So applicant stakeholders have to be very clear on this, that once they do a name reservation in LLP, then they cannot switch back and forth. So that cannot be done. However, one thing that can be that is being taken care is in the new incorporation amendment that is happening, that stakeholder will be enabled to withdraw the name that is allotted to him, but it's not yet available. The service is not yet made. So in case there is a spelling mistake while submitting the proposed name, and it is very obvious that the mistake cannot be continued. So even if the reservation is for 20 days, then there is going to be a provision that the stakeholder can withdraw that name before the expiry of before the reservation expires. So that provision is being brought about in the amendment, but right now it's not available. So stakeholders have to be careful about which format they want to have the company in, whether LLP or company, and accordingly go for name reservation. Then we come to the trademark aspect. So trademark and NIC are very closely related. So now this is, I think, what we have tried to bring in for the first time. Though it was obvious, stakeholders who are very seasoned, they would know very well about this. But to somebody who's going for incorporation or nameability for the first time, he will be now benefiting from this little insight that we have given about how trademark conflict is checked by CRC. So now in the form, in the name reservation form, there is no TM mentioned. There is no trademark class mentioned. So that is very clear. However, each NIC code corresponds to a particular trademark class. So this is how the ROC CRC will evaluate whether there is a registered trademark with that particular within the proposed name. So if within the proposed name, if there is a registered trademark, so and that has to fall in that particular trademark class, which is corresponding to the NIC code mentioned. And since the corporate identification number, your SIN, is taken from the very first NIC code that is mentioned, stakeholders will have to be very mindful that the first NIC code corresponds to the main objects, and that is what is used for evaluating the trademark class and whether it is having any matches or whether it is having any conflict. And then CRC will accordingly raise objection if there is a trademark which is already registered with that particular proposed name. Then it will be sent for resubmission asking for NOC from that particular trademark owner. Now here we have brought about a kind of distinction where we are restricting the category of the trademark to only device mark and not word mark for NOC. For that means what we intend to say is that NOC will be required if the proposed name is having a registered word mark and not if it is having a device mark. Now this can be ensured by the stakeholder when they are actually submitting the proposed name. They can themselves perform a check about the proposed name and with a particular TM class with the help of trademark portal. So the link is given in the advisory itself. So they can go to the trademark portal and appropriately check for the NIC code and the TM class and see if there are any matches. So once there are any matches, then the stakeholders can have two options. Basically, they should get the NOC from that particular stakeholder, or they should appropriately change the name, change the proposed name so that it does not include the trademark which is already registered. So these are the two options available to them. So if they ensure that they act according to this, then there will be very less chance of a rejection or resubmission from ROC CRC. So this is something which is explicitly brought in this advisory. So, and in some cases, ROC may send back for resubmission there if the proposed name is having a trademark registration. And if the stakeholder is able to show with proper documentation that it is only a device mark registration and not a word mark registration, then the NOC requirement will be waived off. Now, one may have this question as to why this distinction is being made all of a sudden. Now, this is actually in line with a Delhi High Court division bench judgment of 2022, Vasundhara Jewellers versus Kirat Vinod Javed Bhai, where the court explicitly mentioned that word mark carries the highest protection, and as a result, device mark holders cannot have any kind of monopoly that the word mark holders have. Now, basically, when we look at a device mark, what is a device mark? So we have an example. If you can see the advisory, can you please scroll to the particular page where we have given a visual. Can you go to page 9? Yeah, page 9. Yes.
Kushbuji, please make the this thing as attachment. No? Share the document. It is not showing on the screen.
And now it is showing, sir. Now it is showing. So a little more you can scroll. Little more you can scroll. Yeah, that's sufficient. So here it's clear now that this kind of distinction, once it is shown, then accordingly ROC will take appropriate action. If it is a word mark, then the stakeholder should ensure that the NOC is submitted. If it is a device mark, then the requirement for NOC is not there. So that the stakeholder can actually take note of, and this is an important thing because we have seen that at least out of 10 trademark queries related resubmissions that go from ROC CRC, almost 7 to 8 are actually of device mark. So this important change was made to keeping in mind the legal position, the latest legal position, and also this will ensure that the stakeholders will not be required to go for NOC when there is no such requirement as per law. So that is an important change that has been brought about in the processing. So any further doubts on this that can be asked during the question and answer session itself. And one more thing here is that we are making this change that NOC can be submitted through a DSC. So this is something which again maybe it's a new thing. We felt that the DSC is convenient, and in fact there were issues within CRC when signature is given of a PAN holder and the signature is not matching. So there are resubmissions owing to that also. So DSC requirement is steering clear of all that, because there will be no confusion about the identity of the person when a digital signature is affixed in the NOC. So this is another thing that is clarified in the advisory. Then one more frequent thing that we come across is in the incorporation, that regarding the utility bill. So many times what happens is that it is a co-working space, and there will be multiple companies having registered offices in the premises. So in those cases, what is additionally required is the copy of the agreement between the company and the co-owner of the the owner of the co-working space. So basically there are three parties here. So the person who is owner of the premise, then he would have given it on lease to the co-working space company, and then the co-working space company in turn would have given it to the company which is now proposing to register itself as a company. So there are three parties. So agreement between the proposed company and the co-working space, the authorized occupant, that is required. In addition to that, the agreement between the owner of the premise as well as the occupant of authorized occupant of the premise. These both documents have to be ensured that it is submitted. So once this is submitted, then there is no further query that will come from the CRC on this. Many times what happens is one of the documents is missing. So you would have attached the agreement between the proposed company and the authorized occupant without giving the agreement of between the company which is the authorized occupant and the owner of the premises. So this is one missing document which results in resubmission of the form, and sometimes it may lead to rejection also if the document is not provided. So this is one more thing that stakeholders may kindly note. And one more thing is about the format in which the NOC has to be provided. Now, NOC, to provide NOC, it has to be, if it's a company, it has to be on the letterhead, authorized letterhead, and it has to be through an authorized person, authorized signatory from the company, and that is a bare minimum requirement. And the ROC will ensure that it is not beyond that. The requirement is not held beyond that. So there is no requirement of a board resolution. Authorized signatory of the company is sufficient to give the NOC in case if it is a company. Then we have also seen that if you come to clause 34, there are many CRFs, the change request forms, that are coming because there is a calculation or a mistake made by the stakeholder in mentioning the authorized capital particulars. Now, this is something which, though internally there is a validation check, but sometimes the validation check may not function, and some stray cases we have noticed that CRFs are being requested for change after the incorporation is over, when there is a mistake in the mentioning of authorized capital in serial number 3 of Spice Part B, and that's not matching with the serial number 6 of Spice Part B, and hence there is a different authorized capital which is appearing in the master data. So stakeholders have to be very careful that this is cross-checked before submitting the Spice Part B form. And then one more thing is that, see, though DIN applications are part of Spice Part B form, it's very clear that once the Spice Part B form is rejected for whatever reason, sometime the requirement is not met properly, the rules not followed while submitting the document, even though for DIN purpose, whatever documents have been given is sufficient, the rejection of Spice Part B will ensure that the DIN application is also rejected. So at a given point of time, 3 people can actually obtain DIN through Spice Part B. The Spice Part B is rejected means your DIN application also goes. So that's no question about it. So we saw that some stakeholders were raising that my DIN application could have been, allowed, but since it's a part of embedded within the Spice Part B, that Spice Part B rejection will cause the DIN application also to be rejected, even though it may be otherwise fine. And vice versa is also true. So your incorporation related things may be fine, but if in a DIN related data providing may be faulty, then also the same thing applies. And one more thing we may look at in this circular is we have tried to compile all the circulars which NCA has issued from time to time on name reservation and incorporation, which are not explicitly stated in the rules. Like, for example, your NOC requirement and this activities of LLP, microfinance in Section 8 companies. All this, the circulars are properly hyperlinked in this advisory, and that should be able to, stakeholders should be able to, see that readily in that advisory itself. It is in one place instead of searching in different places in the website. We have put it in one place so that it is easy for the stakeholder to access. Now, going further, one more thing is that when the company is actually going for a conversion, like it is going for a private company to an LLP or LLP to company. So when I mention LLP to company or any other form to a company, so there the URC1 requirement is there. So you may be aware that URC1 requirement will have a mandatory advertisement period of 30 days. And therefore, we have seen in some instances that stakeholder gets impatient that the incorporation is not happening. But the incorporation is not happening because the mandatory 30-day period is not yet over. The advertisement that has to be awaited. So that stakeholders may please take care accordingly that, the incorporation timelines will vary if it is a URC1 conversion related form. So, and coming back to NIC codes itself, some NIC codes are exclusively associated with government and government agencies. Now, that's clearly mentioned in the advisory also, like the NIC codes beginning with 84. Now, this may be somebody is selecting a NIC code which denotes healthcare sector regulation. Now, that is not possible because a company cannot do a health sector regulation. That is done by the government. So naturally, ROC will not allow that NIC code in the first place. So that's why we thought we'll mention it explicitly that these NIC codes, if they're going to mention, then they should have some kind of a MOU with the government or some kind of an agreement with government, which indicates an outsourcing or something, so that it can be allowed. So otherwise, these NIC codes are, exclusively dealt by the sovereign authority, and therefore they cannot be utilized in the while mentioning the NIC code. So the stakeholders may kindly note that, because we have seen that many rejections and resubmissions have happened on these counts also, where NIC codes which will be denoting the sovereign authorities' right to perform that function is being mentioned in the proposed name. So that is not going to be allowed. Then we have this situation where even minor changes in the company's name, like for example, there may be a hyphen in the company's name which the company wants to remove it, but nevertheless it is part of the incorporation certificate. So when it is part of the incorporation certificate, then such a name, if it has to be changed, any change which is not as per the COI will require a run form filing. Now, why I'm mentioning this? Because there were some cases which happened during the MCA 21's rolling out, back in 2006-7 that the names which were reflecting in the master data were not as per the certificate of incorporation. Now, in these cases, when it is not as per the certificate of incorporation, then your ROC, the jurisdictional ROC, is empowered to carry out the name change, which is as per the certificate of incorporation. So, just a change request form is required to be filed with ROC, and he will carry out the change accordingly, which is as per the COI. Now, if it is not as per the COI, then the change cannot be made, and that requires a run form to be filed. So even if it is a hyphen to be removed, any special character to be removed, that requires a run form. There is no other way.
Sir, one small, sorry to interrupt you, sir.
Yes, please.
One small issue we found in the similar cases when the run form is proposed to be filed, tried to be filed, the
Yes,
system itself is prompting that it is matching with the same name, you cannot take the name. So for removing even one letter or one hyphen or asterisk mark, it is not allowing to apply. So that I know maybe instructed to LTI people that wherever that change is required, whether they can add one more column that you want to rectify the error in the name or go for a new name. If that option is provided, then system will allow us to apply. Otherwise, system is not allowing to apply because the name is same.
Sir, your concern is taken care, sir. I mean, I will personally look into it. Basically, this discussion has already happened internally with LTI, and they are aware of the issue, and I think we'll be able to facilitate form filing in that case also, because presently what's happening is the hyphen and special character is disregarded by the system when the name is being submitted. So yes, the system throws up error, and therefore will not be able to file the form itself. It will restrict the submission in the first place, because it's only looking at the main characters and ignoring the special characters for comparison. So that functionality will be brought in the run. Hopefully that will be done, and then that can be ensured that run can be filed in such cases.
Thank you so much, sir. Thank you.
Yes. So continuing further, we have also seen in page number 15. If you go to page number 15, we have a scenario table clearly marking out all the cases, all the scenarios where likely to face, and here what is the deciding factor ultimately is the place of signing of MOA or AOA. So that is the main, even though you have nationality, citizenship, permanent address, present address. So what is the main deciding factor is the place of signing. As long as the place of signing is within India, the EMOA, EOA requirement kicks in, and similarly EANC 9 will also be applicable. And wherever the place of signing is outside India, does not matter if the person is an Indian or a foreign citizen, then it will require an apostillation or notarization, as the case may be. Apostillation for the signatories to the Apostille Convention, and in other cases consular,ation as may be applicable. So in those cases, physical MOA will be required. Notwithstanding, even if one person is a foreigner who is a subscriber, so it will end up in a physical MOA, even if others are Indian. So this is something which stakeholders to be taking note of, and accordingly they will carry out the requirement of apostillation wherever the signing place is not within India. And I think I've tried to cover most of what the points mentioned in the advisory. Of course, in the same scenario table, you can see that where immigration stamps and passport are required and where it is not required. So that also is explicitly mentioned. So ROC, CRC does have many scenarios that they see in the forms, and based on the inputs that ROC sir has given, this form, this particular table was corrected there from its first iteration. So the stakeholders can see the scenario table properly before going for, filling up the details in the incorporation form. So that's mostly what I intended to cover. So I'll leave the rest of the topic to Anil sir, if maybe he wants to cover other issues. Thank you, sir. I think that's it. What I wanted to cover in this session.
Thank you so much, sir. It's a wonderful and detailed presentation, and a lot of FAQs are covered in this document itself. The advisory will be more useful for all our members. Now, I request, sir, we will take the questions after the Anil sir and Sanjeev sir complete their address, sir.
Yes.
So, Anil sir and Sanjeev sir, please take it forward and give your valuable guidance to members, sir.
Good afternoon, all. Thank you to ICSI, all the participants.
Hello,
Sashiraj
Ramna.
Mankar.
Yeah, yes, sir.
You have to excuse me. I have some other meeting to go ahead.
Oh,
I'll
okay.
leave you in the safe hands of Anil and Varun, and I'll continue. Thank you.
Thank you so much, sir, for
Thank you, sir.
a wonderful cooperation and support from you. And all times you have been there with us for helping the professionals company sector. Thank you, sir.
So, thank you, sir. Thank you, as ICSI once again, all the participants, Sashiraj Dar sir, my colleagues, Varun and Sanjeev ji. So, almost everything has been covered by Varun. Couple of issues I will also discuss. Then we'll go to the question answer sessions. So at the outset, I would like to say the Ministry of Corporate Affairs is constantly endeavoring to promote ease of doing business, and in this pursuit has come up with many circulars, guidelines, and eased the norms, made it very business friendly. CRC. This advisory is one of them. So let's come to directly to the issues. So while Varun was talking, I was noting down some couple of issues. So point number 57 of advisory, if somebody can take me there.
Yes, sir, I'm sharing it.
So I can brief it. While the run application for change of name is filed, I will request all the participants to kindly also attach the current objects of the company, so that we can check the trademark on the basis of the current objects of the company. Otherwise, what happens we at times our system some problem happens, or we are not able to extract the object clause, and we are not able to check what are your objects, and hence it is sent for resubmission. Our motto is to reduce the resubmissions, which we have drastically cut down where we were standing a year ago and today. So that's why I will once again request all of you to attach the objects of the company and duly signed, please. Unsigned documents, many a times we have seen unsigned documents are being furnished to CRC, which is legally not valid. Secondly, with regard to patronage also, mostly in Section 8 companies these days, we are finding that names are coming with Bharat Council of India. Such names, actually, see, if we read the provision of the act, it says it's not about any single word. It's actually the combination of the word, or a single word is so heavily used that together when we read, it gives the impression of a state government, central government, or the local body. See, the intention of the lawmaker was that such names should not be kind of creating confusion in the mind of the public. Our country is not fully literate. We have people who can be very easily duped, and yet there has been cases. So corporate structure have been used to dupe the innocent public. That's why this patronage clause is there. So it should not give the impression of the government patronage of the company's name. With regard to trademark, we have seen we have a shift from earlier. If the NOC was accompanied with the PAN undertaking NOC, the NOC who is providing the NOC was attaching his PAN and then undertaking that, okay, NOC is provided to you. But now the shift is that digitally signed document NOC will be sufficient. So in such situation, please mark it now, digitally signed NOC is required, along with what Varun has already stated with regard to the device thing. One more thing, in Section 8 companies, it is noticed that in AOA, point number 80 to 88 clause, which talks about dividend. So we have seen many of occasions that people are still not making it applicable. Actually, Section 8 company cannot award dividends. So it should be unticked, should not be made applicable. And clause 90 of AOA. So 80 to 88, 90, please ensure that in the first instance itself, you untick it. Untick these 80 to 88 and 90, please note down. So this is our effort to cut down the resubmissions. Similarly, in OPC also, AOA 3 subclause 2, 7 and 8, we have to untick because it talks about further issuance of share, preferential shares, etc. In trademark also, we have observed this thing ki there is a famous trademark is there available with some proprietor, and then we have received applications in which the spelling is a little bit tweaked. So this falls under Section 29, deceptive use of that trademark. So I will request to not to resort to this thing. We have already an enabling clause in trademark, that is Section 35, but kindly evoke it when it is genuinely. Ministry has given an enabling clause, Section 35 of Trademark Act. Kindly go through it, use it, but kindly also read Section 29, not to and refrain from deceptively using the trademark. So, Raju sir, we can now shift to question answer sessions where we can address the queries, and in between we can further elaborate it.
Thank you so much, sir, for your detailed analysis and giving the input, sir, how the members are doing errors in filing the documents and what are the precautions to
I
be.
will not say errors. I will say ki
Maybe
ignorance. They're bona fide. I'll presume it.
Yes, sir. Sir, now the first question is, sir, what is the definition of descriptive like Easy Shops Private Limited or e-commerce views like names are descriptive or not? And when a company is being incorporated, one of the subscribers to the MOA and AOA is a non-resident Indian.
Mm-hmm.
So please tell us that the formalities to be complied with if he is visiting in India for purpose of incorporation, or if he is in abroad, what kind of the documents to be attached.
So that is extensively covered in the advisory from page number 15 to 17. Extensively covered.
Yes, sir. Yes, sir.
15, 16, and 17. With regard to the descriptiveness of the name, see, Easy Shop, is it the correct name which I'm talking? Easy Shop?
Yes, sir. Easy Shops.
So Easy Shops, the name in totality has to be seen along with the objects.
Okay, sir.
Yes.
Then another issue has
Sir, excuse me.
Spice plus Part B modifications.
Sir, just a minute.
My colleague Sanjeev ji has to say something.
Please, sir.
Sir, one more thing I would like to add. In case of foreign directors, when the one subscriber is in the foreign country and one is in India, so two subscriber sheets shall be attached.
Separate, yes.
Separately.
Separate
Indian
sheets.
for Indian witness and foreign for foreigner witness. That should be complied with all the stakeholders so that resubmission will be less.
Actually, he wants to say that the truth is that there is one person who is outside India, one person is in India. So we should have two instead of fabricating it. So the documents should be genuine, true, whatever the situation is.
Okay, sir. Sir, another one is when Spice plus Part B modifications. When any changes are made in Spice plus B modifications, sir, it require all linked forms to be re-prepared. So is there any possibility to avoid the duplication of the work? Can we mechanism where we can retract the old versions and only do the modifications wherever it is required?
Yeah, it is being considered. This is an issue which has already been in the knowledge of the highest authorities, and deliberations are going on to promote ease in this aspect also. So e-governance, Varun is also part of, I believe, that team. Varun
Sir,
ji, please.
actually, I would like to clarify one thing, sir. Here, when stakeholders saying everything has to be, regenerated, see, since there is a interlinking of the form, these forms are linked with each other. The Spice Part B, the Agile Pro, and then your EMOA and EOA. So what happens is, as a consequence of the data which is entered within Spice Part B, it has a bearing on EMOA as well, EOA as well. So these forms are linked. So essentially, what happens is, see, for example, if there is a change in the main Spice Part B itself, the details that are being given in the Spice Part B itself, so then obviously, yes, that will result in the link forms also getting regenerated. But if for some reason it's only a change, only in, let's say, the EMOA of the Spice Part B application, I think then the fields are preserved. The data which is filled in the Spice Part B is very much preserved. So I think that aspect has to be borne in mind. And sometimes what happens is the stakeholders, if they casually click on the form to be regenerated, it will get regenerated. So they have to make changes where only necessary. So if it is in the main Spice Part B form, then of course it has a bearing. We do agree that that is going to cause regeneration of the linked forms. But if it's only the EMOA or EOA, then that alone can be edited and submitted without changing anything in the Spice Part B, which is submitted already. So that, I think, is a key thing that is to be noted. But however, overall re-engineering of Spice Part B is under consideration. More changes may come in how incorporation form may be processed as a part of incorporation amendment that is going to come about. So this is the key thing that should be noted by the stakeholder, that it does not always result in all the forms being regenerated.
Thank you so much, sir. Sir, anyway, the process reengineering is happening. One more request, sir. Many people, even I have been putting it. When the user logged into the system, sir, for like master data extraction, then view signatory, every time it will ask for the captcha. So our request is, once the system identified the user, then till he logged out, it should not again ask for captcha at every point of time. Please look into this aspect, sir.
Definitely, it is required. I have taken it up with e-governance. It is something which is being examined. In fact, now it is only for those stakeholders who are logged in. They can see this. But even for them, there is a multiple captcha which is still happening.
Yes,
which
sir.
I have raised the issue with the service provider, and this is being considered. And there may be some progress in this that you will see. And hopefully, the multiple captcha requirement will be not required anymore. Let us hope that happens soon.
So, thank you so much, sir. The next one is in the AOA forms issues. Frequent session times out are happening, logouts are happening during the preparation of AOA itself, and it is making the issue, creating a lot of waste of time. So system is automatically getting into logged out, and till the preparation done, it is not getting saved. So can any solution be found on this?
Sir, actually, there may be incidences, where AOA such timeout may happen, but it also has to be very sure that that did not happen due to the systemic inadequacies of the stakeholder system. So stakeholder system has to be robust enough. In fact, in the system of stakeholder, from where he's filing the document, it has to ensure that some basic things like cache memory and all that is cleared and taken care of. So sometimes it's very simple things like this also lead to timeout issues. But however, I do acknowledge that there may be some genuine cases of timeouts that may be faced, and in those cases, it has to be taken on a case by case basis. A ticket, as you know, will be raised, and then stakeholder will have to sort it out with the service provider as to what exactly is the issue he's facing, because it is not an issue that everybody is facing. So some definitely do face it. I acknowledge it, and maybe in the business process reengineering, SPICE Part B, this issue will be fully taken care of. But for the time being, the solution is that the user has to raise a ticket and has to describe the issue of the timeout, and then the service provider will appropriately look at the system requirements and whether his system is as per the requirement of filing, and whether there are any inadequacies in the system that has to be taken care of, and then it can be sorted out.
And even in table A format, sir, because after the exemptions and privileges given to government companies, private companies, etc., when we system is throwing the table A format, there is a lot of rearrangement. It is not allowing to add our own articles, so it is causing problem, essentially when the investment process is there, shareholder agreement and all is there. So is there any flexibility can be provided by MCA in relation to this AOA?
Sir, definitely, sir. I'll note it down. I will discuss with the team that these issues are frequently being faced.
So another question is whether attaching the entire agreement copy in respect of registered office is mandatory, or if a copy is just one pager like index is there, which is issued by the authorities, some of the state government authorities. Whether
Take it, Anil sir.
So whether attachment of entire copy of the rental deed or agreement for the registered office is mandatory, or even some cases where the registered document is there, only the acknowledgement of registered rental deed, is it sufficient to attach?
Entire. See,
Entire document should be
Yes.
attached.
entire. It is a very crucial document. It has legal binding, so entire document is required.
Sir, there is a character restriction in the field of registered office address limited to 25 characters, sir. Is there any possibility to add more character to be filled in?
Varunji, please.
Yeah, so this requirement is actually noted by the team. Service provider is also aware of this, but as of now, it will remain 25. I think maybe in the changes that may be taken care of. So I'll nevertheless note down the point. If there's some flexibility that can be provided, that will obviously help. I've noted it down.
One more thing is, sir, when the incorporation process is on, the mobile number of the company, normally the contact details it is asking. So can the promoter number is to be given, or how to modify that number after the incorporation? Because the company is not yet in the incorporation, so.
Sir, the changes can be done. So you are telling the company's contact details, right, sir?
Yes, yes, sir, yes, sir. Mobile number of the company.
So if there is for temporary purpose it is given, later it has to be changed. Then I think, sir, CRF can be filed as of now. Change request form in that the change can be done, which goes through ROC and then to e-governance.
Okay, sir. And in one case, sir, after the incorporation documents are filed, then the remarks are coming like there is a similar trademark. So how at that point of time we can resolve this issue?
Sir, I didn't get the question, sir. Fully. Can you repeat, sir, please?
Sir, name has been allotted, the company's incorporation documents have been filed, and at that time when resubmission has come, that name is similar to another existing company. So anyway the ministry has authority when the similar this thing is there, or even after incorporation, you can give direction to change, or you can yourself change the name itself when it is a resemblance. So it is getting struck at the time of incorporation. So is there any solution we can have for this kind of issues?
Anil, sir, you can take it, sir.
Yes, so we have observed sometimes system does not show properly, the data is not retrieved or properly to check the resemblance or to trademark. In such situations, sometimes some names have been allotted, but name allotment is a different thing. It is actually incorporation of a company. At the time of incorporation of a company, if it is noticed that there is a trademark, so it is usually we cannot incorporate a company with the name which is inconsistent with the name guidelines, incorporation rules. So that is what, so in such situation, it's always better to change the name.
Okay, sir. Sir, another one is Form CRF is for removal of the special characters are only applicable. This question I have already been asked, sir. When then there is a name error on the master data or COI, when we want to remove like words, brackets, or hyphen and all, uh, and the system is not allowing. Varun sir, as you told, please give the.
The issue is under your consideration, sir. It will be addressed very soon. That this it will be enabled to file in such cases. And if there is a further delay, then on a case-to-case basis also that can be taken up. But I am hoping that this issue will be resolved very soon.
Okay.
It is under consideration. Yes.
Sir, another one is there is a character, how group companies can be incorporated by a new company with the same if the advisory says that cannot be taken up. Because then in the group companies, sir, most of the prefix will be the same. Just they will change the suffixes of activities in the name itself. So whether NOC is required for every this thing.
Anil sir, you can take it, sir.
So it's simple. See, sir is asking a question. It may be a group company, prefix may be same. There must be some distinction, some activity or some new word must be there.
As long as it is not identical, I think
Yes,
ROC would not have a problem.
it's quite. We are allotting.
Oh, okay, sir. So
Okay.
is there any option that where it is belongs to any group if in the
Sir,
column?
identical name cannot be given in any situation.
Yeah, that's okay, sir.
Yeah. Be it a group or not a group, be it LLP or be it a company or section 8. There was a question which I received. So it cannot be. Identical has to be avoided, disregarding the type of the company or body corporate.
At the time of incorporation, it is not decided whether it is a group company or not. Later on, when you are filing financial statement, on these days you will decide whether it is a group company or not. So at the time of incorporation, it is not needed at all.
Yeah. Sir, one more thing, sir. In case of incorporation of a private company where foreign director is there, if the director is present in India and having his passport entry in India and foreign resident address proofs attested by professionals, when without apostolization, can it be taken up, sir?
So valid business visa is required actually in that case, along with the immigration stamp on passport.
See, with regard to signing of document by Indian in foreign or foreigner in India or various multiple permutations, it is extensively covered in advisory page 15, 16, and 17. All possibilities have been, jotted down there.
Okay, sir.
And
Sir-
we request all the participants to kindly go through those and try to submit the documents accordingly. Once again, I'm saying our motto is to cut down resubmission, promote ease of doing business.
Yes.
And
Sir, one more thing, sir. In the
separately.
latest, economic scenario, especially like Bombay and Bangalore places where co-working space is allocated for the companies. They initially start up like wife and husband small business entity they want to do, and they don't have specific agreements or lease deeds except that allotment of a portion for usage. So in those kind of situations, how the rental deed requirement can be fulfilled.
So there must be a trail of documents at least which says that, okay, you have been authorized to use this premise.
Okay.
I mean, understand, there must be a trail. The premise must be belonging to X, then Y is sharing this thing. So there must be sharing a document, the lease deed, which X has leased his or her property to Y. So trail must be clear. There has been cases once reported in newspapers as well that fabricated NOCs have been provided.
Right, sir. Absolutely correct. And sir, one more thing. Once an LLP or company's name is approved, because of the documentation part, we have seen the situations of war zones where the directors are located in different places, apostolization is not getting happening. So the when promoters wants again same name, even after 90 days also they could not file the documents. So is there any possibility that auto release of the same name can be allowed?
Sir, there is a renewal of name process is there. You can renew up to twice, I think.
90 days we can do, sir. With
Yes.
they already exhausted those two options as well.
You file again, but yeah, current scenario says ki file it again. If you want it renewal to be extended beyond 90 days, Varunji will note it and may take it further.
Varun sir, one request is if after 90 days, even if they want, maybe the same extension may not be allowed, but at least the name may be considered to be allowed. Because
I'll
the
take
name is
note of
already
the,
already given.
okay, I'll take note of the points that were raised. I'll discuss with the team.
Well, generally it is allowed.
Yeah.
In 99% case, name is almost allowed.
Unless until another body corporate has been incorporated with the same name.
Right.
Yes, sir. And sir, whenever there is a error, Varun sir, you have already explained that whenever there is a human error in their name application, well, they are applying, they can disown that name and go for a new name. So that 20 days or 30 days, they have to wait for the lapsing that name. So when we withdraw, sir, is there any possibility that withdrawal letter may be attached to that run form itself and for easy consideration for the correct spelling name?
So I am see the scenario which you are describing is that the stakeholder himself is withdrawing the name because due to spelling error or something.
Spelling
Yes.
it. Yes, and he is attaching with the run form that old name given, and so that easily it can be considered. Only correction, only letters correction or something.
Okay, okay, I'll clarify here that this provision is being brought about in the amendment that is coming in the incorporation rules.
Yes, sir.
So once that are notified, the incorporation amendments are notified, then there will be a specific provision which will enable the stakeholder to himself withdraw the name, though there will be a reservation which is still valid for 20 days or 90 days as the case may be. So as of now, I think the stakeholder cannot himself withdraw the name.
Withdrawal is not allowed, but then, okay, since the motto of the government is to promote ease, so they can file it with declaration, duly signed, duly affidavit, they must attach. And in such cases, it's preferably the form should be once again be filed by the same ID applicant with which the earlier name was approved, so that there is a genuinity.
And declaration is signed by professional because professional has more authenticity.
Okay, sir. Sir,
Because any other stakeholder filing, so we cannot rely on his or her document, who is, how, why he is filing. And once professional is certifying, then it is genuine case. Then we can consider.
okay, sir. Sir, another thing is, sir, this since the company's activities and objects will be wider, definitely, and there is some cases where NIC code exactly did not match with the activity because it falls in multiple NIC codes, sir. So how to resolve this issue, sir? When the multiple, because some activity may fall under one NIC code and another activity also fall under some other code.
Sir, what we can think of is we can have in the public domain itself the NIC trademark master, which from where we derive the TM class from the NIC code. So that will give ample clarity. Right now, what I see is that when we check in the internet, in the Google, and then based on the NIC code, it does throw the TM class. Mostly, it is accurate. And though it is accurate, it will be better that we have it in the public domain. I had discussed with ROC Anil sir also that we can put this in the public domain as to what NIC code constitutes what TM class, and that will give more clarity. There need not be further researching on that. Having said that, see, I'll give you the context. Earlier, I think 4 or 5 years back, the form had only one NIC code, and then it was add two more NIC codes were added. Now, what happens is the more the number of NIC codes, the more the chances of TM conflict. So it may or may not be the company's main business. See, when three NIC codes are entered, the first NIC code is what is picked up in the same. So we have restricted the conflict assessment mostly to the first NIC code, and the trademark checking happens on the basis of the first NIC code that is entered. So that's let me make that clear. And because see, there is a possibility that the company may engage in a lot of activities, a lot of objects may be engaging in. There is no provision to have all that number of NIC codes in the form. It is not feasible to evaluate conflict. Let's say if we have 10 NIC code provision and somebody enters 10 NIC codes, it's not feasible to have evaluating 10 NIC codes and trademark conflicts in that sense. So we will have to ensure that the company selects its most prominent business, most prominent object, and accordingly go with the NIC code that is going to be included. So that's what I would suggest. The company can carry out some other objects which are not main objects of the company, and those will not be taken by the CRC for consideration of TM conflict. Only the main first NIC code will be considered.
Okay, sir. Sir, even in the trademark, this
But
thing,
here I would like to add one couple of things. The first NIC in case of finance, the first NIC should be 64. You can't make just to evade the trademark. We cannot have the finance activity as 64. 64 as second or third NIC. It should be then first because it's a
It's the
activity.
main activity of the company.
Yeah, main activity. So 64.
Being governed by RBI.
So 64 and 66, if there are there, these should be first.
okay, sir. Sir, in the trademark, this thing also, because it has been worked extensively on the trademark. One thing, sir, in the trademark, there is a nice classification, which is having a different multiple activities in one clause itself. And where the company is already like, for example, if you take clause 5, it is a pharmaceutical. In pharmaceutical, manufacturing may be there, or formulation may be there, trading may be there, any other things may be there. So that NSE classification, what we take, the name is getting rejected even for like cosmetics drugs selling shop cannot be allowed for manufacturer name, drugs manufacturer name which is allocated by some other company. So how we can segregate that, even under the same clause also the activities may be different because of the nice classification, because even the trademark act is not, classification is not so extensive as NIC classification. So is there any possibility that we can give more advisory on the trademark and classification aspect compared to NIC classification?
Sir, actually in the incorporation amendment, there is a change that is coming there. Like, we'll give the example of beverage. Okay, if a company, if a beverage is a trademark class, and beverage includes coffee, it includes tea, it includes some other beverages as well. So, if the objects of the company that is going to be formed is only in the domain of coffee and does not touch tea, and if the trademark class, the person who has got the trademark is actually into tea production and not at all into coffee production, so it has to be amply clear. Let's be clear on that. It has to be very clear on that. And in those cases, the conflict will be reassessed. But this is as per the new incorporation amendments that are going to come about. So this is what I think will probably help, where the trademark class maybe, because one thing is very clear: the number of NIC codes are obviously near about 1500, whereas the trademark class is only around 45.
Yes,
So
sir.
invariably there will be instances where that multiple NIC codes will eventually fall in the same TM class. So in the particular example that I gave, this case will be considered, but this is pursuant to the incorporation amendment rule that is going to be coming.
Even today, we are checking the sub activities. But yes, as Vanu sir said, ki so much of preciseness, tea and coffee is yet to come. It is awaited.
So this will be taken care in the incorporation amendment rule.
Right.
Yes.
Because some of the questions are coming up from the members, even keeping in view of the proposed amendments and proposed changes to be coming in the incorporation rules also. Sir, in LLP, only 3 proposed deals are allowed for the designated partners in film. So, is there any possibility when 4 or more subscribers or 4 or more partners has to be added there?
Sir, it is, sir, basically 3. And if you see Spice Part B, there also the current number is 3. And yes, sir, I think e-governance is aware, the service provider is also aware that there have been some requests for having more number of bins allotted. Maybe, sir, it is, I think at this point of time, I cannot comment on what stage it is, whether it is being taken up or not. The prospect of allowing more number of bins in the incorporation application. I am not yet aware of the latest of this. I will take this point and then further I'll get back to this.
Okay, sir. Sir, the system is not allowing to complete the company's address to be entered in single line, restricting the proper addressing formatting because the addresses are different in different towns and cities. So how can we modify this clause?
Sir, I think, you already told about the number of characters, which is restricted. Maybe what you're saying is if the number of characters are increased, then it would be taken care, right, sir? That's what you're...
Yes, sir. Because somewhere they will say in line opposite to so and so like this. So then maybe some fields are allowed extra so that we can give full address details.
I have noted it, sir. I have noted it.
Sir, one more thing is since this as from 1st April now today, the income tax is department is modifying that PAN, TAN, these things. So now incorporation certificates, whatever getting this thing that necessary arrangement or necessary alignment to be done in the system where that it will match with the income tax department new systems. It is only a suggestion.
Yes, sir. I didn't get fully what you
The
call
income
certificate.
tax department is now changing the PAN and TAN application.
Yes, sir. Correct. You're right. You're right. Yes, sir.
So
Yes.
when company incorporation today or tomorrow, it should not. That's the PAN certificates will be automatically generated. No, so MCA system should be aligned with the income tax authority system.
Sir, on this, sir, one update that I have as of now is that since the change has just been made, there may be some intermittent issues in the time required to get the certificate of incorporation, the PAN. There may be some issues, but it is likely to be resolved in a couple of days. And wherever, sir, stakeholders may face issue on the COI generation or PAN generation, they're requested to raise a ticket and a service provider will assist them accordingly. But the issue will be mostly resolved within 3-4 days. The intermittent issues that stakeholders may likely face.
So when the errors are occurring while entering the PAN details, even when data is correctly imported from the Excel sheet, what can be the solution, sir? Because the PAN is correctly entered also, system is throwing an error that the details are not correct.
Sir, then I think...
some cases.
Okay, sir. These specific instances have to be looked at by the service provider, sir. We may, if that's provided to us, sir, we will take it up. Ticket may be raised already, I feel. If the tickets are raised, then resolution would be provided in all these cases. And so it may be an isolated instance. I would like to believe that it's an isolated instance.
Okay, sir. Another issue, sir, in the resubmission process, when a form is marked for resubmission, the system requires resubmission of all linked forms, even when the issue is only in relation to one single form.
Sir, I think I tried to give a clarification earlier. So the issue is if this main spice part B requires a correction, then all the forms do get regenerated and they have to fill it up, again. But if it is only about the separate link form change like the EMOA or EAOA, then I don't think the system is asking to fill everything once again. The auto population is there.
Sir, in this matter, sir, only one request that at least that OTP regeneration. Because multiple times we are asking the promoters, especially the big entrepreneurs, send every time because form it is not getting uploaded, we are redoing it. It is
Understood.
giving a very problem for promoters. So please, at least this part, like the OTPs will not go again and again because that person already has signed the document. Only the errors have come in that document. So any
Correct, sir. Correct. Sir, this issue is also noted. Definitely, there is scope for improving the process here. I do agree that this OTP requirement asking after he has given already, that will cause some issues. This is under knowledge of e-governance, sir, and they're working on it, sir.
Then the current system, sir, requires a manual entry of details of the entities relating to directors in which they are interested, like the entities. So since the data is already with MCA, once the data is filled in, when that data automatically can pop up from the internal data available with the ministry, and maybe some other field additional columns if we need to add, there we can add, sir. Because it is wasting a lot of time entering 15 companies, 20 companies details.
Correct, sir. Your suggestion is valid. It's taken, sir. In fact, we have already discussed this with the service provider. It is under consideration to have this properly pre-filled. The moment the DIN is entered, the pre-fill should happen as to how many companies the person is already a director. Agreed, sir. Agreed.
Yeah, thank you, sir. Then another one is one hypothetical case, sir, where the user has tried to file one spice part A, where by mistake chosen limited by guarantee. But in part B, every other document, the share capital details and everything has been given. And the shares are provided in the master data. So how to resolve this issue when the master data is already generated as a guarantee company, though the details are filled in the forms with the capital details. It's a error of the user itself, but some solution may be required.
Sir, it can be rectified at the time of filing MGT7. Once he file MGT7, at that time he can rectify the type of company. So he need to wait for some time.
It will automatically populate, sir, or it will allow.
No, you need to select whether it is a type of guarantee company or another company. That time it can be rectified.
So once again, if the details are incorrectly selected, so once again, when you are filing the MGT7, at that point of time, by putting in correct details, you can have a correction.
Can CRF
or CRF to the jurisdictional
CRF mechanism can be allowed, sir, maybe allowed.
Right.
Yeah, the CRF mechanism has to be looked at if, the wait cannot be till MGT7. Yes.
Oh, okay, sir. There are a lot of queries are coming up, sir, because they say MCA day-to-day activities. Sir, one more thing is when the company's name is allotted and the company maybe in the new system era to come, they may withdraw and go for the change in the structure of the company like Section 82 and all. So in the system, sir, whether it will be automatically submission mode or how it will be, sir. While filing this run itself, we can surrender and ask for the new name. How it will be happening, sir? If the new system comes.
As far as let's take a specific case. A Section 8 company has to surrender its license if it is going for a conversion. So that process cannot be avoided. That process has to be completed.
No.
So any particular changes, I mean, we can have something simultaneously happening to reduce the number of filings that we can take into consideration. But the process still remains that first it has to surrender the license of Section 8 company.
Sir, one more thing, sir, regarding registered office details itself. There is a concept like virtual offices are getting incorporated now because of the software companies and software dynamics coming in the market. So when the virtual office address is there to be given for the company, whether documents like leave and license agreement, the co-working space agreements, NOCs, these kind of things, whether is there any possibility to consider by the ministry in future?
Sir, actually, when we see the rules, Companies Act rules on record management, yes, I mean it does allow instance where a company need not keep all its records in the registered office itself. It can keep elsewhere as well. So there is a filing also for that. I believe it is AOC 5. So if the company is able to file AOC 5, then the records can be kept in some other place, and that some other place includes a virtual space as well. But as far as registered office requirement is concerned, as of now, the Companies Act does not allow for a virtual registered office. But having said that, it does allow for companies to have their records elsewhere other than registered office.
Okay, sir.
The compliance of Section 12 should be made, na? That's why we are not allowing.
Yes, yes.
Sir, sometimes like there will be a trademark for one like name ABC, which is a registered trademark. But unfortunately, other fellow has incorporated with the same name like ABC Private Limited. So the remedy available for the person who is having a trademark, authentic trademark, is this only rectification of name, sir, or any other mechanism they can use?
Yes, Section 16
Yes,
has
16,
to be
yes.
availed. Yes.
Sir, there is one more case where the private limited company was incorporated in 1998. The name of the company name was a private limited in the system, certificate of incorporation. But in the master data, the name is not coming as a private limited. It is coming as a limited. So how to rectify these issues, whether CRF can be allowed on this matter?
Sir, if I got your question right, the master data is showing the company's name as
Yeah, limited, sir.
limited. But as
Company
per
certificate
certificate of
is having private limited.
Oh, sir, in this case, ROC, jurisdictional ROC will be able to correct. There is a
But
back office
what happened
functionality.
since 1998?
Yes, sir, 98.
It's
So
almost
they can
30
make CRF.
It is
will
almost
be
30
corrected.
years now, 28 years.
Through CRF, they can change their
Yes,
details.
yes. So CRF, the back office functionality is provided to ROC, but that change should be exactly as per the certificate of incorporation. No
Yeah.
change will be allowed, which is not as per the CY.
In case of agile forms, sir, the specific attachment, whatever are there, people are able to attach. But when additional attachments, additional documents are asked for, how to resolve this? Because there is some cases where the documents what is sought by the regulator is not available with the parties. They cannot provide.
Can you provide some instance, sir, like what sort of documents?
This details.
Only a specimen signature, two photo,
Huh.
and one ID address proof they are asking. Nothing more they are asking. So they can be provided very easily by the stakeholder.
Okay, so because the instant they are not provided.
Sir, every who is applying for company incorporation must have their ID, specimen signature and photo. They must have, they can upload, no issue.
Sir, in the OTP verification process, the system is not allowing to proceed without completing the OTP verification in initial stage. This is restricting filing of forms in advance when the directors are not immediately available for OTP. So the filing process is getting delayed. Because the people are, in different countries, the directors whose signature is used.
I understood, sir. The practical difficulties are there. Noted your point. In fact, we have also internally discussed about this. There is scope for making an improvement here. Definitely, we can do it, sir. I think we'll get an update shortly on this OTP related changes that may happen.
Even after this introduction, 3 years DI3 KYC, half of the problem is solved. Otherwise, every year we are getting
Yes, sir. Right.
for foreign directors. It is really good initiative by MCA at least. We are getting 3 years once KYC updation is very easily handled situation.
Correct, sir. Correct.
Sir, one more thing, sir. In the case of regulatories, industry-specific regulators, at the time of name availability, some of the times the regulator is not interested to give any in principle these things, sir. Because you first incorporate the company, then come to us like that. They are telling. So how to handle this?
Okay. See,
Whether
I think
undertaking.
in the advisory, we have mentioned two instances. I think the ROC CRC is also sticking to those two instances. I believe that where the proposed name is having, bank, specifically the word bank is there, and specifically insurance is mentioned in the proposed name itself. Only there, I think, only there is an insistence for prior NOC. But in all other instances, if the company is intending to pursue the objects of banking or insurance, the declaration is inbuilt in the Spice Part B. So Spice Part B has an inbuilt declaration that will suffice, and there should be no further, declaration that is asked for in these cases.
The actual problem coming up with the only insurance broking company, sir, where it happens is every automobile dealer will have to have a insurance broking company for the vehicles they sell. They want to have their own company to get that commission from the insurance companies for that life insurance and all, that insurance of vehicles and all. So when we go and apply for IRD sort of authority, they will say that first incorporate, we cannot do anything till you come up with the incorporation documents, certificate of incorporation.
Sir,
So
that concern is noted. But having said that, the main the main object of the company is not insurance, right? You are saying incidental.
Insurance broking, yes, incidental activity.
Incidental. So
But in the name, the insurance broking word is used there.
okay. So, I believe, sir. Okay, I have just noted it. But presently, sir, when the word is used directly in the proposed name,
At
these
least
two
undertaking, sir, undertaking or affidavit format where they will say they are not going to start up any activity till this provide they along with the 20 AR document they will submit the approval of the regulator. At least that they, by that you can give the name.
I have noted it, but as of now, sir, this is the position that declaration is inbuilt in Spice Part B, and we are insisting for prior approval only for bank and insurance. Now, your requirement is that there may be companies which are having the name within the name itself, and then you want to give a undertaking.
That is one of the hypothetical I am telling, sir. Maybe there may be some other situation.
Okay.
Like chit fund activities, then state government, they never know that, chit fund names may, why they have to give approval or NOC.
Okay. For chit fund, it is very, what is the thing is that the name should clearly convey that it is engaging in the chit fund business.
Yeah, but individual approval they cannot get, no, sir. Different state governments have different mindset and perception thought process.
Mhm.
They never have in their system to give any NOC sort of thing or in principle
There is no such mechanism that they have.
mechanism there for them.
But sir, it happens only in those cases where the chit fund company is not registered as a chit fund company with such a register. Once it is registered with that register of chit fund, they will provide NOC.
No,
Most of the
name
cases they are not
availability,
registered anywhere.
name availability stage I am telling, sir.
Nameability, no issue, sir. Nameability chit fund can be allowed very easily. Nothing. In case of change of name, it is required.
Okay.
Once it is changing from chit fund to chit fund.
Sir, one suggestion from even my side, sir. CCFS is coming up. As you know, there are many companies which will go for a restoration of companies with the NCLTs, which are having assets and not filed and struck off. So, sir, any possibility that MCA can introduce a form where after attaching the NCLT order and certification by the professional, the company's name automatically get restored. Backend, scrutiny may happen, but what is the problem is when we get by the time we get the order from the NCLT itself, it will take 15, 20 days or 30 days. After that, time of the scheme may get lapsed. So the very purpose of getting that company restored will get defeated. Because of this scheme, many professionals will rush to the NCLTs for getting the restorations. So once they get restoration, if you submit to the ROCs from the backend, ROCs also they are putting a lot of their effort to clear the documents, but the load may be more. Instead of that, a system may be introduced that for restoration specific form or this thing with the attachment and certification by professional with the certified copy of the NCLT order, automatically company get restored and filings can happen easily, smoothly within the CCFS timelines.
Okay, I'll convey it to e-governance. I mean, the concern is noted. Definitely, it is going to help. I agree. But I'll convey this requirement.
And one more request is, sir, as you know, because we also try to reach the corporates and entrepreneurs, but since the MCA is having the data of all the directors and these things, if you sensitize that CCFS scheme is available through the MCA system by sending information messages to the directors themselves, because we going and contacting each and every director to come forward and avail the scheme, it is we will do our best as a professionals, but the reachability what MCA has with their database is something robust. So you can sensitize that CCFS scheme is there. You can avail that benefit with the directors' mobile numbers as you have, because data privacy is there, so we cannot do anything. Only MCA can do something on this. You have their mail IDs and their mobile numbers.
Right, sir. Right. So as of now, it has not gone. The message has not gone to their email IDs or mobile numbers provided. So therefore, your request is that it can auto-generate a message of this scheme to all of them. Fine, sir.
At least when they find that mail, they will contact the professionals whom they are regularly.
Yes, sir. Yes. I have noted the points. Yes. Yes.
So thank you very much, sir, for your patience. Kushbuji, is there anything to be taken up or?
Yes, sir. We can close the session, sir.
Yeah, thank you very much.
Thank you, sir. Thank you. Thank
Sir,
you.
let me formally close the session, sir.
Yes, sir.
Yeah, at the outset, sir, Varun sir, your detailed description of the advisory. First of all, we would like to thank and appreciate the advice, the thought of releasing the advisory for incorporation name is a really excellent step taken by the ministry. With this advisory, a lot of stakeholders will have the resolution for majority of their problems. Maybe most of the problems will get resolved once they go through this advisory. It's a wonderful document, sir. Really a great effort by the ministry for the benefit of stakeholders. Thank you very much, sir. And you have given the detailed, description about this advisory, which is very useful for all our participants. Thank you on behalf of ICSA, sir, for patiently listening all the questions and giving answers and guiding us how to take up all the issues. Thank you so much, sir.
Thank you so much. And I would also like to acknowledge contribution of CRC
Yeah,
team.
yeah, I have to close the, I have to
Yes, sir.
thank
Their
them.
inputs were very valuable in
Yeah,
in this
Once
activity.
again, I would also like to thank all the participants, and I will with a request to incorporate all the suggestions, advices given by us, so that your applications should not be the resubmissions should be minimized, and your applications gets through in one go itself.
Sir, Anil Yadav sir and Sanjeev sir, really, we are very delighted to have you here from the front end, because we always have a back end connect, but not from the front end. But coming forward to address our members, giving the guidance to our members is a wonderful initiative of MCA. And you have cleared lot many doubts and lot many, missing things what you find in incorporation, and this will add lot of value to our members, sir. One more thing, sir, we having come and spending so much of time, we really wants to give our heartfelt thanks to both of you, and we will be having many more similar approach you for similar kind of webinars, taking your support and guidance all times. Dear members, I have one information for you. The ICSI has released on its website, it has put up on 23rd March 2026 to solicit feedback on Corporate Law Amendment Bill 2026, and asking you to send a mail to the Companies Act 2013 at icsi.edu. If you provide that, whatever your suggestions and your feedback on the amendment bill, it will be definitely useful for our own fraternity as well as for the stakeholders. So requesting all to spend some time to review this document, amendment bill, and give your suggestions, sir. Khushbuji, I have done with. Thank you so much once again, sir, for our wonderful session.
Thank you so much, sir. Thank you.
Right, so thank you.
Thank you.